What's up, everybody? Welcome back in. We've got our answer. We've been waiting for some time. What is Judge Cannoni going to do? Is she going to dismiss the charges? Is she going to declare that the jury came to a verdict and they are not guilty on 2 of the 3 counts against Karen Reed? Is she going to give a juror interview? We get our answer today as her order has come down, and we are going to read through the entire thing together live. So hit that like button and subscribe if you have not already. Let's get into it. So I've actually been unable to even read through this today. I've had so much going on, so many different things I had to do and take care of on this Friday. That's why we're going live at 3:30 instead of 3 o'clock, because I had to finish a few things before we could actually sit down together, dig into this, break it down, answer questions. I don't even know her reasoning. I know it was denied. I know that she denied the defense's motion, that she denied dismissing this case. I think and assume she denied a juror interview, but I don't know because I haven't read the order yet. So let's read it together. No surprise, right, that she denied it, but I thought there was a chance for a juror interview. On June 9th, a Norfolk County grand jury indicted defendant Karen Reed on charges of M in the second degree, manslaughter while operating under the influence of alcohol and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe, on January 29, 2022. Trial on the matter began on April of 2024. There were 8 weeks of evidence and nearly 5 days of deliberations. After the jurors expressed to the court that they were deadlocked for a third time, the court declared a mistrial. The defendant now moves to dismiss the charges for murder in the second degree and leaving the scene of the personal injury and death, arguing that retrial would violate the double jeopardy protections of the federal and state constitutions because the jury, in fact, reached a unanimous verdict to acquit the defendant on those charges. Alternatively, the defendant argues that dismissal is required because there was no manifest necessity to support the declaration of the mistrial with respect to those charges. After careful consideration, this court concludes that because the defendant was not acquitted of any charges and defense counsel consented to the court's declaration of a mistrial, double jeopardy is not implicated by retrial of the defendant. Therefore, the motion is denied. Okay? Legally speaking and technically speaking, I understand how a judge could come to this decision, okay, based on the information we have. But also based on the information we have and based on this being the justice system, the manifest necessity, I got to be honest, from the jump, I never thought that was a good argument. That's just my opinion. But the jury coming to unanimous verdict, we have more information than just, well, we don't know what happened back there and they never publicly announced their verdict. It's like, oh, seriously? Seriously? That's the one I don't like. That's the one I don't get. That's the one I don't understand why we don't have an interview with these jurors to figure out what actually happened. Did they actually come to an agreement? Because if they did, we can't in America retry somebody for those charges. All right, let's get into it here. The background. We all know the background, but we'll read through it. On June 25th, 2024, the jury began its deliberations in the defendant's trial. In addition to 3 indictments, the court had instructed the jury to consider 2 lesser included offenses to the manslaughter while operating under the influence of alcohol, involuntary manslaughter, and motor vehicle homicide. On Friday, June 28th at approximately 12:10, the jury foreperson sent a note to the court stating, "I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict." So again, multiple ways to read this. Any unanimous verdict or any individual unanimous verdict. What does that actually mean? At the time, we all thought they were deadlocked. They can't reach a unanimous verdict. We're not going to have a verdict in this case. I'll just say that's what I thought at the time. Hindsight, obviously being 2020, maybe we know something different now. The court requested argument from the Commonwealth and the defense as to whether there had been due and thorough deliberation from the jury. ADA Lally, on behalf of the Commonwealth, argued the jury had not had sufficient time to deliberate, and therefore it was too early in the deliberative process to give the Tui Rodriguez instruction. He also pointed out that although the note indicated that the jury had not yet come to a conclusion, it did not indicate that doing so was not possible. Yannetti, on behalf of the defendant, disagreed with Lally's characterization of the note. He argued, and now we've got a block quote of what he argued, and we remember all of this. And again, I kind of thought the defense wanted to get the mistrial, wanted the Tui Rodriguez, wanted this mistrial. That was my initial inclination at the time. And I was surprised because I thought they had won the trial. I thought they would push for a verdict, but it seemed like Lally was more pushing for the verdict than the defense. And if you go back and watch my videos, that's exactly what I said in real time. The word exhaustive is the word I think is operative here. The jury is communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and that they're at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try and get a report they were not allowed to get. And I think the message has been received that the evidence is closed, and they won't get anything more. They've been essentially working nonstop over the last 3 days, 4 days. We're approaching a weekend. They didn't come back with this at 3 or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is that the jury should be read the Tui Rodriguez model instruction and go from there. That's what Yannetti said. The court ruled that given the length of the trial, the number of exhibits, and the witnesses and the complexity of the issues, that the jury had only been deliberating for 3 days. Deliberations had not been sufficiently due and thorough to warrant a Tui Rodriguez instruction. It instructed the jury to continue deliberating. So one thing that's important here, because we do this with lawyers and there's no reason we can't do it with judges as well. As I read her background, okay, as I read how she remembers and believes the facts went at the end of the trial, let me know if you disagree with her take on the facts. Because reasonable minds can differ, right? We can see things differently than the judge, just like we see things differently sometimes than lawyers. So I'm going to keep reading here. On Monday, July 1st, 2024, at approximately 10:45 a.m., the jury sent another note to this court that said, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry. Ultimately, leading to a point where consensus is unattainable, we recognize the weight of the admission and the implication it holds. The court again requested argument from counsel as to whether there had been due and thorough deliberations. The Commonwealth argued that the jury had been deliberating 22 to 23 hours, but given the length of the trial, number of exhibits and witnesses and complexity of the issues, they had not done thorough deliberation up to this point. Attorney Yannetti, again, vastly different. Now she adds her little snark to it, vastly different. He argued, our view is that it is time for the Tui Rodriguez instruction. They have come back twice, indicating essentially that they're hopelessly deadlocked, but the content of this latest message is that they have been over all the evidence. The previous message said that they did an exhaustive review. This time it said that they have fundamental disagreements about what the evidence means. It's a matter of opinion. It's not a lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they have done that. This is what Tui Rodriguez is for. The court agreed that the jury had engaged in due and thorough deliberations, noting that this jury had been extraordinary and it had never seen a note like this from a jury. It thereafter provided the jury with the full Tui Rodriguez instruction and asked them to return the deliberations with those instructions in mind. The same day at approximately 2:30 p.m., the jury sent another note to the court. The court stated to counsel that the jury was at an impasse. After the jurors filed into the courtroom, the court read the note. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Again, I will say here, as we're reading these notes again, they're not exactly giving off any indication that they've come to an agreement on 2/3 of the charges. On the vast majority of the questions in front of them, they're not indicating to the court or anybody else that they do have agreement there. They are kind of saying, we are vastly different. We can't come to an agreement. We're at an impasse. We're deadlocked. It's fundamental differences on the evidence. Now, because we have more information, I still think a jury interview should have happened. But at the time, you can understand why maybe nobody saw this coming. Our perspectives on this are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges. Beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. Again, charges plural. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm going to answer a few questions, then we're going to get to this footnote. Dragon, Bev would need to care in order to interview the jury. Now, I do think that an appeal is going to happen. She's entitled to an appeal. Paul Printed Heart said, can she appeal this? Yes. But it's going to be tough because this might just be squarely within the judge's discretion. And if the appellate court finds she didn't abuse her discretion, which is a pretty high standard, it may just stand, which sucks. I wish she would have used her discretion to get to truth and justice, interview these jurors, figure out if they had come to unanimous agreements and just didn't understand that they were allowed to write that down on the verdict form, and we figure that out. I don't understand why not do this. What is anybody afraid of at this point? You can do it sealed. You can do it in chambers. Nobody has to be there. That would be totally reasonable and appropriate under these circumstances. But let's get to the truth. That's what I don't understand. Hi, Peter. So will they appeal and have an answer on the appeal before January? We'll see. We'll see if they pause the trial, if they do an interlocutory appeal. We'll see. Ezekiel, the amount of snark this judge puts into this written decision shows clear as day her extreme bias. Voting people of mass, please don't let these turkeys keep their jobs, judge and the prosecutors. I definitely think she is annoyed, especially because the defense say that she didn't give him an opportunity to argue the mistrial, that she didn't do her job right. And when you bring arguments like that, certain judges with certain personalities take offense and get annoyed. Okay? If you remember back to the Maya trial, and we'll take Judge Carroll, for example, the lawyers took some shots at him, especially Howard Hunter. I don't feel like he cared. I don't feel like it bothered him at all. I felt like he understands what's going on. I feel like Judge Cannoni, on the other hand, sometimes took offense to the way or things the defense counsel said during the trial. And this order is no different. All right. The Tui Rodriguez instruction, this is our footnote, states, our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be obtained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with the proper regard for respect of each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment. Now, do they understand that indictment and the charges are the same thing? There are some ambiguities there potentially, but it definitely, there is some language here to stand on. Then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. Not on all of them. You don't have to do them all at once, but on that indictment. In conferring together, you are to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who find that the defendant is not guilty should consider whether the doubt in their minds is a reasonable one. If it makes no impression on their minds of the other jurors that are equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought to seriously ask themselves whether they may not reasonably doubt the correctness of their judgment. If it is to be shared by the other members of the jury, they should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. After reading this note, the court declared a mistrial and discharged the jury back to the deliberation room to wait for the judge. Counsel remained in the courtroom to discuss an agreeable date of return for the status conference. So here's what else I'll say. I think the judge did state that fact correctly. After reading the note, she declared a mistrial. She didn't ask for arguments again. And that's one of the issues the defense has. And she didn't try to sugarcoat it. She said, that's what I did. I found that interesting. Mandy said, can they ask for recusal if they win the appeal? Yeah, they can always ask for recusal, but I don't know if it's true. I don't know if it's true. On July 8th, the defendant filed the instant motion to dismiss, supported by affidavits from Attorney Yannetti and co-counsel Attorney Jackson. Attorney Jackson's affidavit stated that on July 2nd, 2024, a juror in the case contacted him. Jackson was able to identify the person as a deliberating juror based on his or her description of who he or she is, where they were seated, and certainly identifying information, name, and occupation disclosed during the voir dire process. According to Jackson's affidavit, Juror A told him that he or she wished to inform him of the true results of the deliberations because he or she believed those results significantly impacted the defendant's rights. Juror A said the jury unanimously agreed that the defendant was not guilty of counts 1 and 3, and specifically that the murder charge was off the table. In his affidavit, Jackson also stated that neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked and on which count or counts the jury may have arrived at the verdict. So again, I know a lot of people disagree with me, okay, but this last part, where they really argue the manifest necessity and that they weren't given the opportunity to argue with this mistrial, they didn't consent to it. I really personally think that's a bad argument. I understand why they make it, and legally, I think they have an argument, but I think it's just like an appeal. When you talk about throwing multiple things against the wall to see what sticks, sometimes your good arguments lose weight. And I think they're amazing, absolutely incredible argument that's wild, that almost never happens in cases, is all of these jurors are coming out, not all of them, 5+ jurors are coming out saying, we had unanimous verdicts. We want to tell the court that. That's an amazing argument. That's amazing evidence you have after the trial that really affects this trial. That's what I would have focused on. I would have pretty much gone with a Hail Mary. Now, I understand they're protecting that argument for appeal and making it here, but I think that it starts to lose water and lose weight when you make this argument that feels disingenuous to me, that I don't feel like they had this argument at the time or they ever would have made it at that time. But people can disagree, and I know people will disagree with me about that, but from the jump, this has made their argument feel a little weaker to me. Yannetti's affidavit averred that on July 3rd, he received communication from 2 informants who had received information from 2 deliberating jurors. The first sent him a screenshot of text messages. Yannetti averred that he was able to positively identify the jurors. In the screenshot, the text message said it was not guilty on second degree and split in half for the second charge. When the judge sent us back with the Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Yannetti stated that another informant contacted him, knew a previous juror, coworker of that juror. Text message stated there was no consideration for M2. Manslaughter started polling at 6-6, ended in a deadlock. Yannetti's affidavit said that. The text back said, interesting. If there was no consideration for M2, shouldn't she have been acquitted and hung on the remaining charges? To go back to the jury slip, goes back to the jury slip. That was confusing. The juror informant C texted, she should have been acquitted. I agree. Yes, the remaining charges were hung on, and that instruction paper was very confusing. Yannetti stated that based on the description of juror C he received from the informant C, the description of juror C told the intermediary C he could positively identify juror C was a deliberating juror. Yannetti later filed a supplement supporting the motion to dismiss that stated he received an unsolicited call from the individual identifying themselves as juror B. Juror B told Yannetti that they were familiar with the affidavit previously filed, and they confirmed the substance and conversation between informant B and intermediary B. Juror B clarified that he or she meant to write, no one thought she hit him on purpose or even knew that she had hit him. On July 10th, Jackson submitted a supplemental affidavit stating that on July 8th, Juror D contacted him, identified that he knew who Juror D was, and they were able to confirm it, that he or she was uncomfortable with how the trial ended. Juror D said that it was very troubling that the entire case ended without the jury being asked about each count, and especially count 1 and count 3. Jackson also said that Juror D told him that the jury agreed the defendant was not guilty on counts 1 and 3. They disagreed solely on count 2's lesser offenses. It's kind of confusing whether it was count 2 or count 2's lesser offenses. I think the majority say lesser offenses, but sometimes it's not clear. But that they believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any counts, which again, that's incorrect. They believed that. They had a belief that was incorrect. If we know that, let's fix it. We can fix it. It's not unfixable. Nobody else goes to prison if we fix this. You know, that's the frustrating thing to me. It's not like the mistake was the other way and we're not sure and we're going to throw somebody in jail for the rest of their life based on something that we don't know. It's like, no, this is the opposite. We're talking about somebody's freedom. Let's get to the truth of the matter. Juror D believed all the jurors would corroborate his or her account. He or she also stated if necessary, they would testify before the court as long as their identity remained protected. On July 18th, another affidavit, Juror E, who was able to be identified, stated the jury was unanimous on counts 1 and 3. She even says, also stated, that the defendant was not guilty of those charges and that they were deadlocked on one of the lower charges on count 2. August 1st, Commonwealth filed a post-trial notice of disclosure stating ADA Lally received 2 unsolicited voicemails from an individual identifying themselves as a deliberating juror and said they were unanimous on counts 1 and 3. Commonwealth also received emails from 3 individuals identifying themselves as jurors stating they wish to speak anonymously. In its response to the emails, the Commonwealth stated that it was ethically prohibited from inquiring as to the substance of the jury deliberations and that it could not promise confidentiality as it may be required to disclose substance of any conversation to the defendant or court. All 3 jurors declined to communicate further with the Commonwealth. So what's interesting about this is, just like I thought when they came back hung, Jackson wanted it to be a mistrial, Lally wanted them to keep pushing. When they start getting reached out to by jurors, the defense wanted to know what they had to say. The Commonwealth was like, no, we're good. We're good. We're happy with what you said. We don't want to know anything about that. That's what I feel. Recusal is a catch-22. Biased judges don't recuse. I know it's such a crazy, I always hated that when you want to get a judge disqualified, you first have to ask that judge to disqualify themselves. Good judges would already disqualify themselves when things started popping up like this. Mom to 8 said, please cover Madeline Soto. A bunch of people have asked about that. I'm hoping by September 1st, we'll have an announcement for you that may allow us to hit more cases than we're currently able to hit. Elizabeth, if the jury had been polled at that time, would the judge have polled each count individually? Yes. Peter, what do you mean by Hail Mary? So in football, when you're down by, a touchdown and you got one play left, only one play and one shot, a Hail Mary is when all the receivers run downfield. The quarterback throws the ball as far and high as he can into the end zone, and you hope you get lucky and one of your people come down and catch the ball. That's a Hail Mary. So it's like a last-ditch effort. All right, let's get back to it now. We finally get to the discussion. We're done with the background and the facts and how we got here. The Fifth Amendment to the United States Constitution, applicable to the states through the 14th Amendment and to the United States Constitution and Massachusetts common and statutory law, protect an individual defendant from being twice placed in jeopardy for the same crime. The double jeopardy clause affords a criminal defendant a valued right to have his trial completed by a particular tribunal. A defendant is entitled to protection from double jeopardy if there had been some event, such as an acquittal, which terminates the original jeopardy, or if a mistrial is entered without the defendant's request or consent, unless there was a manifest necessity for the mistrial. The interest in giving the prosecution one complete opportunity to convict those who have violated its laws justifies treating the jury's inability to reach a verdict as a non-event that does not bar retrial. In her motion to dismiss, the defendant argues that retrial on indictments 1 and 3 would violate the double jeopardy protections of the federal and state constitution because, despite absence of a jury verdict, the jury in fact reached a unanimous verdict to acquit her on those charges, or alternatively because there was no manifest necessity to support the declaration of the mistrial with respect to the charges. After careful consideration, the court concludes that the defendant's arguments are without merit. So just summarily, all the arguments are without merit. Acquittal of the defendant. The defendant first contends that she was acquitted on indictments 1 and 3, and therefore retrial is barred based on her attorney's affidavits purporting to reflect statements by jurors that the jury reached a unanimous conclusion that she was not guilty on those charges. Although all the statements in the affidavits are from purported jurors who wish to remain anonymous for the purposes of this motion, the court accepts the statements as true and accurate. Okay? So the court, this is one of the things the defense asked. If we need the jurors to come in, judge, we'll bring them in. If these affidavits aren't enough, we'll bring them in. Well, the judge is saying those affidavits are enough. Those affidavits are enough. I am taking them as true and accurate. But even doing so, any agreement among the jurors as to counts 1 and 3 cannot be considered acquittals for purposes of double jeopardy. So she's saying that, number one, I'm taking what they say as true. But even with that, not enough for an acquittal. So to me, and again, it's the first time I'm reading this. This is my initial reaction. To me, it sounds like she's saying, we don't need a juror interview. I don't really care what the rest of the jurors say, because even if they all come in here and say, we would have voted not guilty, that's still not enough for an acquittal. That's what it sounds like to me. You guys can let me know if you hear or read something different. To trigger double jeopardy protection, an acquittal requires a verdict on the facts and merits. A person shall not be held to answer a second indictment or complaint for a crime of which it has been acquitted upon the facts and merits. She keep facts and merits. Is she going to make a big deal out of that? Because I would say if they come and say not guilty, it was based on the facts and the merits. And the only verdict which can be reviewed and regarded as a complete and valid verdict is an open and public verdict, affirmed in open court as the unanimous act of the jury and in the presence of the whole panel, so that each juror has an opportunity to express his dissent to the court in case his decision has been mistaken or misrepresented by the foreman or his fellows, or in case he has been forced into acquiescence by improper means. So, a couple things about that. Some very vague and interesting arguments that we heard up to this point, and it's no surprise that the judge took the easier way out and doesn't want to have this happen again. But what I will say is there's two ways. I don't think open and public verdict necessarily means the same thing the judge is saying here. I can understand the defense's argument that the confusion necessitates a juror interview. And then potentially a juror interview in public and open court amongst all their other jurors, wouldn't that be sufficient? One could argue. The verdict shall be unanimous. It shall be a general verdict returned by the jury to the judge in open court. The jury shall file a verdict slip with the court upon the return of the verdict. As such, the weight of the final adjudication cannot be given to any jury action that is not returned in a final verdict, and a distinction must be made between agreement on a verdict and return receipt and recording of a verdict. So they're sticking to the fact that this didn't happen in open court right after the trial. I don't see the language right after the trial in any of these arguments, but that's what she's saying. All right. Because there were no, hold on a second. I'm getting a bunch of text messages. Going to make sure it's not from John and Kelsey here. No, we're good. Because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any charges. The unanimous act of the jury here was their representation to the court that they were at an impasse and unable to agree on whether the Commonwealth had established beyond a reasonable doubt the elements of the charges. And she does italicize the charges. And because of the Tui Rodriguez instruction, which we read above, it does mention charges and indictments, plural, multiple times. I kind of get what she's doing. She's lawyering here. It almost feels like she's arguing for a certain position, right? Sometimes it feels that way with judges' orders because they've got to back up and explain why they came to the decision that they did. And sometimes it feels and sounds adversarial. This one definitely does. The purported later attestations by some jurors after they had been dismissed that the jury had in fact agreed on some of the charges during deliberations do not have the force of a final verdict. I wonder if she's going to talk about outside influence or anything like that. I don't know, but we'll see. After a mistrial was declared due to deadlock, the judge did not err in refusing to accept signed verdict slips recovered from the deliberation room showing not guilty because it is not enough to show that the jury may have agreed on some issues at some time if that limited showing were to control, uncertainties would be invited. And again, we already heard that argument that they had filled them out in the jury room back there, but they didn't turn them in and they didn't come to a unanimous verdict. Nobody came out and said, hey, we had a unanimous verdict, but that's the Commonwealth and the judge are saying that's even a step further than we have in this case, and it was not double jeopardy in that case. Therefore, it's not here. I would say there's a difference in between these two cases that all the jurors are saying now, so it seems that there was a unanimous verdict and it never changed. It wasn't at some time, but that was the final verdict. So I would just like to know the answer to that. And if one juror said that's not true, I was still going to vote guilty. It's over. I don't want to hear this argument anymore. It's over. A mistrial was appropriate. But we don't have that. And that's what sucks. And that's what in my like justice mind and body, as like superhero of justice is so hard to get over. Not that I'm a superhero of justice, just saying like when you push for justice, it's really hard when you hear that to just get over it. Double jeopardy did not bar retrial after hung jury where 4-person reported unanimous vote on offense before deliberations had concluded, but deadlock was the conclusion. The defendant argues that it is elevating form over substance to not accept that the statements of the affidavits reflect an acquittal of the defendant's counts 1 and 3. However, the rendering of a verdict in open court is not a ministerial act as the defendant contends. Rather, it communicates the finality of the deliberations, and its pronouncement in open court ensures its unanimity. Public affirmation in open court provides safeguards against mistakes. I agree with that, but we can still provide safeguards against those mistakes, right? Indeed, the authority upon which the defendant relies places particular importance upon the jury's pronouncement of its findings in open court. The foreman's announcement in open court that the jury was unanimous against a conviction on the capital and first-degree M was an acquittal for double jeopardy purposes. Peter, I don't understand why we aren't asking the jurors. Is the judge the only one stopping it? Can they go around her? I mean, they can definitely appeal it, but the more time that passes, the more times you lose, the more rulings against you, the harder it is. That's just how it is in the law. Judges know that. Lawyers know that. That's why sometimes they're like, well, we'll just let the appellate court handle that. How many times have we heard Judge Landville say that? The 4-person's announcement in open court. We got that. Thus, a verdict in substance is a final collective decision reached after full deliberations, consideration, and compromise among the individual jurors. And when that decision is announced in open court, it becomes entitled to full double jeopardy protection. Deciding to give effects to the verdict received from the lips of the foreman in open court would elevate from form over substance. Where there was no verdict announced in open court, here, retrial of the defendant does not violate the principle of double jeopardy. Let's read this footnote. In written and oral argument, the defendant also relies on language from Taylor. Taylor discussed whether a judicial determination to terminate proceeding based on a procedural ground implicated double jeopardy. The Supreme Judicial Court explained, what constitutes an acquittal is to be controlled by the form of the judge's actions and that the determination does not depend on check marks on a form. This language in Taylor does not inform the court as to the circumstances here. So she's saying that's different. I'm going to differentiate that case from this case, and therefore I can still go forward and say, oh, no verdict, no public announcement. This is not form over substance. This is not a verdict or an acquittal for purposes of double jeopardy at all. Okay, manifest necessities. Now we're getting to the next argument. A defendant's motion to dismiss also argues double jeopardy bars reprosecution because she did not consent to a mistrial and there was no manifest necessity to declare one. This argument, too, is without merit. A defendant's consent to a mistrial removes any double jeopardy bar to retrial. Consent may be explicit or implicit. Explicit consent may occur by either moving for a mistrial or agreeing to one. Consent to and again, this is just annoying again, how the judge handled this. Like, why didn't you just ask for arguments like you did every other time? But she didn't. Explicit consent may occur by either moving for a mistrial or agreeing to one. Consent to a mistrial may be implied where the defendant had the opportunity to object to a declaration of a mistrial and failed to do so. Where the defendant sits silently by and does not object to a declaration of a mistrial, even though he has a fair opportunity to do so, a court may presume his consent. I agree with this part. I do. I know you guys are not going to like it, but I agree with this part. A court may infer consent only where the circumstances positively indicated defendant's willingness to acquiesce to the ministerial order. Consent to a mistrial need not be expressed, but may be implied from the totality of the circumstances attendant on a declaration of a mistrial. As noted, the court here declared a mistrial after the jury reported 3 times that they were deadlocked. After the second time, the court determined that the jury had engaged in due and thorough deliberations and gave the Tui-Rodriguez instruction before sending the jury to deliberate further. Massachusetts general laws provides that if a jury, after due and thorough deliberations, returns to the court having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberations. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. If after due and thorough deliberations, the jury twice advises the court that they are unable to reach a verdict, the court may not properly send the jury out again without their consent, unless the jury asks for some further explanation of the law. It's kind of funny as we read this, right? And we read through all this case law while they were deliberating, while the mistrial was going to happen, the deadlock, the Tui-Rodriguez instruction. We did this research. We talked about this stuff. We read this case law. So we kind of know where they're going, but this is exactly how the law works. Multiple people can read the same case. Multiple lawyers who do this for a living, and judges are lawyers, can read the same case law, see the same facts, and apply it differently. That's why we have judges, because two people are going to argue differently, and we see where the judge falls. In their note to the court, the jury specifically stated to continue to deliberate would be futile and only serve to force us to compromise on these deeply held beliefs, making it clear that they would not consent to continuing their deliberation. Yannetti twice argued for the court to give the Tui-Rodriguez instruction, the final step before the court would declare a mistrial. And that's where I think I have a different opinion from some people that are non-lawyers, is you're pushing for that because it starts the clock. You don't usually push for the Tui-Rodriguez instruction because you think you're going to win and you want them to deliberate further. I know some people disagree with that, especially that haven't done it before, but I've been in cases where we've had deadlocked juries. And the side who's pushing for it to be a mistrial or pushing for that final instruction usually wants the mistrial. It's just my opinion. Counsel's request for the Tui-Rodriguez instruction permitted the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. Specifically on Friday, June 28th, after 3 days of deliberations, the jury sent their first note indicating that they had engaged in an exhaustive review of the evidence and had been unable to reach a unanimous verdict. Yannetti argued the jury had engaged in due and thorough deliberations, was at an impasse, and should be given the Tui-Rodriguez instruction. The following Monday, when the jury was sent out a second note after deliberating for approximately 2 hours, stating consensus was unattainable. Yannetti again argued that due and thorough deliberations had occurred and described the jury as hopelessly deadlocked. Defense counsel, in arguing twice that due and thorough deliberations had occurred and pushing for the instruction, presumably was aware of the legal implications if the jury returned deadlocked again. Nevertheless, in a remarkable turnaround, defense counsel now argues, again, remarkable turnaround. She's like, whoa, whoa, whoa. Defense counsel now argues that twice they advocated was sudden and unexpected. Got to be honest, when I read that, I was kind of like, Although the court did not specifically ask defense counsel if they had any objection to the declaration of mistrial, which was a mistake, counsel had multiple opportunities to voice an objection if they, in fact, had one. While waiting for the jury to enter the courtroom after the court announced the jury was at an impasse, on the afternoon of July 1st, defense counsel could have asked to be heard on the issue. During the subsequent discussion about scheduling and status hearing, right after the court declared a mistrial, counsel had yet another opportunity to inform the court of its dissatisfaction. Lastly, counsel could have communicated to the court any objection or request to poll the jurors while the jury was still sitting at the courthouse and waiting in the deliberation room after the declaration of a mistrial. I don't disagree with her there. Instead, the defense counsel said nothing to the court about the mistrial and then proceeded to the courthouse steps where Attorney Jackson declared to the media and onlookers that the Commonwealth failed miserably and will continue to fail with its prosecution of the defendant. Again, some snark. But I will say, I kind of had the same feeling when all this was coming down and the first time we heard these arguments. I did kind of have the same feeling. But I get it if you guys disagree. Azam, Peter, I don't understand that people voted for one to become judge. If the people voted for the judges, can the people fire them as well? So if I think these judges are appointed in Massachusetts, I don't know, in Florida, they're voted for. You can vote them out, but it's only during their terms and if they have opposition. You can't just immediately vote them out and get them fired unless, of course, they do something illegal or, horrible where they, get disbarred or something like that. But the voting process happens every number of years, depending on the jurisdiction. How does the position for judges work? Do they have a certain duration of time working as judges? Yes, they have terms. Tara, wouldn't the attorneys need a few minutes to process the note directly? to mistrial, to excusing jury to figure out if they had any questions. Judge did not give them time. Listen, I get it, and we can all try to make arguments, right? If you want to try to argue for that side, I think there are arguments to be made. And I think you can make them. I think I could make them. But I'll just tell you, we all watch trials together, right? And I handle trials myself. You always have to be doing multiple things at once. You can be talking to your client, reading a deposition, listening to a witness, objecting. If you are doing all that stuff at once and you do not object timely to a question that is inadmissible or improper, you waive it. You're not given time. They don't say, pause, give me 5 minutes to think about this, judge. We saw it in the Daybell Vallow case with Judge Boyce. He was like, untimely, therefore denied. I'm not even going to listen to your objection because it was too late. And it was like quick. Most judges will let you, give you reasonable time during the answer to object during the answer. Boyce didn't. And that's not improper. Lawyers are not given an infinite amount of time. They have to be able to think on their feet. It's hard. It's not always fair. It's not always perfect. But it's the same thing we talk about with statute of limitations. There has to be a time limit on certain things. And when it comes to objections or making arguments like this, it has to happen in real time or you waive it. That's how it goes on appeal. If I don't do things during trial, and I've had defense lawyers argue about this with me in civil cases, and it's annoying. It's like, you didn't even object during it. You submitted those jury instructions. Why are you arguing about it now? You waived that argument. And they could say, well, we didn't have proper time to think about it, but that's not a proper argument on appeal. And it's also true that Judge Cannoni screwed up and should have asked them for their thoughts and if they had any objections at the time. Okay, after she talks about the courthouse steps and she cites YouTube for those courthouse steps, it strains credulity to believe that if defense counsel wanted to voice any objection to the court, it would not have been heard. Significantly, defense counsel were no shrinking violets. Neither Attorney Jackson or Yannetti has ever needed this court to inquire whether counsel had an objection in order to be heard, and the court has never denied counsel the opportunity to be heard in open court or at sidebar. I, again, agree with this. And I kind of said this in one of my previous videos, like, these guys they weren't wallflowers. They weren't, shrinking into their seats. They weren't scared. They were going to fight for their client. They were going to be heard. They were going to make sure that nothing was done without their objection. Nothing improper was done without their objection, as they should. And now that's a blessing and a curse, right? And that's kind of why I thought this argument weakened their really strong argument that I think they should have won on to get a jury interview. The court reconvened many times at counsel's request. Just days before the declaration of the mistrial, defense counsel asked to address the court while the jury was deliberating to raise an objection about the verdict slip. Attorney Jackson was not shy in informing the court that he wanted to make his argument and that the court's decision about the verdict slip was not how it should be, and it's over our strong objection. Now, here's a problem I have. It's one thing for me to talk about this on YouTube. It's another thing for her to use the defense attorneys doing their job against them in an order. So she has to be very careful. It's a fine line that she's walking here to show some bias and potentially be the subject of a motion to recuse her and disqualify her. She's got to be careful. Attorney Jackson went so far as to suggest that it was almost like the court is directing a verdict of the subordinate charge by not making changes he wanted. The court finds it hard to believe that when counsel heard that the jury was at an impasse for a third time and a mistrial was inevitable, at perhaps the most crucial point of the trial, counsel would sit silently if they did not consent to a mistrial. I don't disagree with her there. As such, the court does not credit Attorney Jackson's avertment that he lacked an opportunity to be heard. Defense counsel's silence, despite ample opportunity to be heard, is deemed consent. When the trial judge on own initiative declared mistrial, defendant's silence was deemed consent where there was ample time to object despite not being directly asked by the judge. So it's not demanded that the judge ask. Silence was not consent where judge's conduct was so intimidating to defense counsel as to the foreclosure of any objection from defense counsel to the declaration of mistrial. And you notice that the defense did not argue this language. They didn't argue that they were so intimidated by the judge. A, I don't think they would have argued that. B, it would not have been true. But that's where you have to get where their silence isn't taken as consent. Okay? Even assuming arguendo that the defendant here did not consent to a mistrial, the law is clear that retrial is permissible so long as there was a manifest necessity for the mistrial. This judge's The trial judge's belief that the jury is unable to reach a verdict has long been considered the classic basis for a proper mistrial. I agree with her. Describing a hung jury as the prototypical example of manifest necessity. It means you have to do it, right? You have to do it. Because the court here had no doubt, based on the jury's notes to the court, that it was unable to reach a unanimous verdict, and the jury represented to the court that continued deliberations would be futile, there was manifest necessity for this mistrial based on the deadlock. As stated above, the foreperson on behalf of the jury in this case sent the court 3 notes, none of which indicated agreement on any of the charges. In the first note, the jury wrote that they had been unable to reach a unanimous verdict. The second note, they stated they were deeply divided by fundamental differences in our opinions and state of mind, and that consensus was unattainable. In their third and final note, after they had been given the 2-year Rodriguez instruction, the jury stated they continued to be at an impasse. They described themselves as starkly divided on their perspectives of the evidence, explaining some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find that the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Some repetition here. It didn't have to be 21 pages, it seems. The only reasonable interpretation of these notes, and specifically the final note, was that the jury could not agree on any of the 3 charges, and further deliberations would serve no purpose. Now, we know that's not true, right? We know that's not true at this point. That's the tough part. For the defense to now claim that the notes were susceptible to different interpretations, such that the court should have inquired further rings hollow, particularly where Attorney Yannetti had twice argued that the jury had engaged in due and thorough deliberations and could not agree. No abuse of discretion in declaring a mistrial given the increasingly adamant manner in which the jurors announced they were deadlocked. Moreover, defense counsel's conduct immediately after the declaration of the mistrial in no way suggests they thought otherwise. Let's read this footnote. Given the care that went into writing the notes and how articulately they expressed the jurors' disagreement, it strikes the court as odd that there was no inkling of indication of agreement in the content of the notes, or that if the jurors were uncertain whether they could return a partial verdict, they would not have asked the court. But we know that there was a problem now. That's the problem. And you said you took the affidavits as true, Judge. So now that you know it, doesn't it change these footnotes? It's like she's saying she's taking them as true, but she doesn't actually believe what's written in the verdict, in the affidavits, because the affidavits say at the time we all agreed and we never disagreed again on those counts. Peter, would it be reasonable for the defense to assume the jury was hung on all the charges? Yes, I assumed it. Would they think the judge would be impartial and say otherwise if she knew? Did she ask them after, you think? No, I absolutely don't think she asked them after. I think everybody was fine with the mistrial at that point. CJ, Peter, I understand what you are saying, but isn't the judge supposed to ask if they wanted to poll the jury? No, not always. Sometimes they do, but not always on a hung jury. Always when there's a verdict, but not always on a hung jury in my experience. I know it's a moot point now. Yeah, but I get what you're saying. I definitely think she should have asked the attorneys, do you have an objection to the mistrial? Do you have any comments after the jury note? I absolutely think she dropped the ball there. But was it an abuse of discretion? Was it reversible error? I don't know. The defendant contends that the court failed to carefully consider that as an alternative to a mistrial. It could have simply asked the jury to specify which charges they were deadlocked. Reed's motion dismissed at 8 is where the citation is. However, the question whether a mistrial is appropriate in the circumstances of a given case is not answered by application of a mechanical formula. Rather, the court considered several factors, such as the statements of the jury's notes concerning their inability to reach an agreement, the time spent in deliberation, the length and complexity of the trial. We have never required a trial judge before declaring a mistrial based on a jury deadlock to force the jury to deliberate for a minimum period of time, to question the jurors individually, to consult with or obtain the consent of either the prosecutor or defense counsel, to issue a supplemental jury instruction, or to consider any other means of breaking the impasse. So there's nothing that forces them to poll the jury. Because again, we don't want any undue influence making a jury vote a certain way if that's not their actual vote. Where here, the jury had been deliberating 5 days, had returned to the court 3 times, stating that they could not agree, had been given the Tui Rodriguez instruction and returned hours later with a note plainly indicating they could not agree as to the elements of the charges and that to continue to deliberate would be futile. Asking the jury on which charges they were deadlocked was not necessary to determine whether there was manifest necessity for a mistrial. Citing a case that said where the final note from the jury foreperson unequivocally stated the jury was unable to come to a unanimous decision, the judge was not required to inquire whether there was any reasonable probability of a unanimous verdict or if the jury would consent to further deliberations. Reading these cases, though, it gives you some ideas that you wish would have happened at the time, right? The judge did not err in declining to poll the jury when further instructions or deliberation would be likely to result in or likely to resolve the deadlock. We know it's more than likely to resolve the deadlock that wasn't there on a couple charges, right? That's the thing, is she's dismissing the fact that we have more information now. Moreover, the defendant's argument ignores the fact that one of the three charges had lesser included offenses. Therefore, if upon questioning, the jury had indicated to the court that they were not deadlocked on all charges, the only option would have been for the court to send back the jury for further deliberations. The judge should not inquire as to partial verdicts on lesser included offenses. Again, that's not what we have here, though. Such action would be improperly coercive under the circumstances. It has been repeatedly recognized that deadlocked juries are particularly susceptible to coercion. Where the jurors have twice reported themselves deadlocked and have already heard the Tui Rodriguez charge, a judge's inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from this trial. Where here, the jury had before it one indictment which it had included lesser included offenses, had 3 times reported themselves deadlocked on separate charges, had already heard the Tui Rodriguez instruction, and had sent a final note indicating that continued deliberations would only serve to force them to compromise their deeply held beliefs. Sending them to deliberate further would have been improperly coercive. Just got lightheaded reading that. The defendant's argument suggests that questioning or polling jurors who report a deadlock is best practice, or at least commonly done by trial judges. However, the defendant has not cited any cases as much, and indeed, such an inquiry is not undertaken in the regular course. For a judge to make such an inquiry on her own accord could impede upon the strategic decision of counsel to not make such a request. The defendant's argument is based in hindsight. No one other than the jury knew that questioning the jurors as to their deadlock would have yielded a favorable outcome for the defendant. But we know it now, which is at least, if the judge is taking those statements as true, should the prosecutor, which means they should drop these charges. It is likely for that reason, defense counsel consented to this court's declaration of mistrial, meaning they didn't know what was going to happen. They didn't know it was going to be good for them. That's why they consented. Post-trial inquiry. Here we go. The defendant alternatively requests that the court allow counsel to conduct a post-trial inquiry of the jurors to substantiate the existence of an acquittal. Such inquiry is impermissible. The defendant's argument relies solely on Commonwealth versus McCallop. In McCallop, the Supreme Judicial Court held that the trial court should have allowed the defendant's motion for jurors' names and contact information based on post-trial statements of deliberating jurors regarding racist comments made during deliberations. The Supreme Judicial Court explained the presence of even one juror who is not impartial violated the defendant's right to a trial by an impartial jury. Recognizing that racial bias in the jury system is a familiar and recurring evil that, if left unaddressed, would risk systematic injury to the administration of justice, the McCallop court held that the defendant should have been given a fair opportunity to obtain an affidavit from that juror setting forth with some specificity who among the jurors made statements reflecting racial bias and the statements that were made. So in that case, basically, you can't have a racist juror saying, I'm going to convict them because of their race, and you have to overturn that because, we care about justice. The defendant's argument here does not implicate racial bias or her right to receive an impartial trial. See, that's where I disagree with the judge. While this is not racial bias, it still comes down to a fair and impartial jury coming to a unanimous verdict and us getting the just result. In this case, it declined to extend racial bias exception to inquiry of jury unanimity because infection of the criminal justice system with racial or ethnic bias is a unique type of constitutional deprivation that requires a vigilant response not warranted to the circumstances presented here. So they didn't extend it in other cases, and the judge is not going to extend it here. The defendant's request effectively seeks permission from the court to inquire from deliberating jurors that which is impermissible, information regarding the substance of the jury's deliberation. She's agreeing with the Commonwealth. Shocker. The secrecy of jury deliberations has served as a bedrock of our judicial system, and inquiry into the jury's deliberative process would intrude improperly into the jury's function. It is simply not the case, given the content of the jury's final note to the court, that any inquiry to the jurors now could be limited solely to the results of the deliberative process and not implicate the process itself. Any inquiry would necessarily require the court to understand why the juror's final note communicated a deadlock on the charges when post-trial certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges. While the defendant contends that the conflict is reflective of the fact that the instructions given to the jury, by the court were confusing, determining whether this issue is true would necessarily require inquiry into the back and forth among the jurors during deliberations. The judge is precluded from inquiring into the internal decision-making process of the jury as a whole or of the individual juror being questioned. Accordingly, evidence that the jurors misunderstood the instruction of the presiding judge cannot be considered. Thus, such an inquiry is prohibited. So if you remember, the defense specifically was like, just ask them a couple questions. Was it a unanimous verdict, and was it your unanimous verdict at the end? Don't ask them if they were confused. Don't ask them about the deliberative process. Don't ask them about the back and forth. Don't ask them anything impermissible. Judge says no. The defense counsel has not cited one case suggesting a post-trial inquiry they now seek is appropriate or that it could change the outcome of the proceedings. For the reasons already discussed, an acquittal of the defendant now on indictments 1 and 3 based on conclusions properly or purportedly reached during the jury's deliberations is not possible. I would say presumably, not purportedly, because you presumed them to be true, but whatever. She's showing that she doesn't actually think they're true. Therefore, there is no reason for the court to allow post-trial inquiry of the jurors. No error in denial of the motion to subpoena foreman, where a process would only serve to impeach the jury's report to the judge in open court. I will say the defense's motion was a little light on case law that said you can do exactly this. Conclusion and order. This court recognizes that the bar on retrials following acquittal is perhaps the most fundamental rule in the history of double jeopardy jurisprudence. Didn't feel like you were holding it in such high esteem, Judge, but however, where there was no acquittal on any of the charges in the defendant's first trial, there is no risk of subjecting the defendant to double jeopardy by retrial on all the charges. To say that you believe those affidavits and to also say there's no risk of subjecting the defendant to double jeopardy, that doesn't bode well to me. That doesn't bode well to me. I don't feel like those two things go together. Can trial be tossed out due to current corruption with the MPD? I feel like as more stuff comes out, the more shady it looks, Bev needs to go as well. So can it be tossed? Sure. Prosecutors can toss it for a number of reasons. Charlie, is there a jury instruction that can, when multiple penetrate issues are charged, they state if any of the unanimous verdicts, they state 1, 3, 2, 3, etc. So there are ways to do better verdict forms and jury instructions. Yes, I think that's what you're asking. The four-person, is the jury unable to reach a verdict on all of the 3 charges? Yes, that's a simple fix, but it's in hindsight now, and they didn't ask for it at the time. Heather, did you hear the hot mic where it sounds like the judge says we never changed the forms? It was hard for me to make out exactly what was said. Yes, I did hear people talking about that. I did. EDB, what's up? Says, hey, Chad, has lawyer lost his mind yet? Mind is still intact. It's not that surprising the way she came down with it. But I think maybe they've got some fodder to file a motion to DQ her because she's biased against him. I think they maybe got a little bit of that. It's unfortunate. And really, I wish the prosecutor would do the right thing here, because while the judge has some legal loopholes that she can, settle into and maybe not abuse her discretion by giving this exact order, the prosecutors, in the interest of justice, if we're going to presume those affidavits are true like the judge did here, how do you not throw out these charges, the counts 1 and 2? Bodie said, Peter, I emailed you about Sarah Boone's latest motion where the lawyer is billing for watching your Boone videos. If you want to check the email, that is hilarious. I did get that email. I'll have to check it out, and maybe that'll be a video for this weekend. But that is pretty funny. Pretty funny. Emily said there was for sure some Judge Snark. Oh yeah, she did not miss an opportunity to throw some shade at the lawyers for how they treated her, and they weren't afraid of her or intimidated by her. They made that clear. All right. Boom. Right at the 1 hour mark. Love when the videos hit on time. Make sure you guys hit the like button. Make sure you let me know how you feel in the chat and subscribe to our page. We're crawling towards 500K. So I appreciate you guys so much. I appreciate you being here, continuing this ride. And I have a feeling it's not over. So we will continue to follow along. John said I was cited. Kind of was cited. We'll take a look at that motion probably this weekend and post that video. Thank you, Azam, for the super sticker on the way out. I appreciate everybody joining us. Yeah, Charlie, I got you. We're on the same wavelength, buddy. But until next time, we're out of here. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.